put your lighters up. New York, put your lighters up. DC, keep putting your lighters up. Philadelphia, put your lighters up. Detroit, put your lighters up. Chi-Town, keep putting them lighters up. No matter where you're from, put your lighters up. Let me give you a walkthrough.
Next on your honors list is Kimberly Jones. Your Honor, this is his sentencing.
Where is she? Is she in the booth? Is she in the basement?
I'm right here, Your Honor.
Oh, I didn't recognize you. You're so well dressed today.
Yes, Your Honor, we are here for sentencing today, and I believe that Your Honor has a copy of the pre-sentence investigation.
I do. I've read it. Have the defendant sworn in.
Kimberly Jones, please raise your right hand.
Okay.
Kim, I need your gun hand.
Oh,
Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Little Kim, would you please state your name and spell it for the court?
My name is Lil Kim. Capital L, capital I, capital L, apostrophe, capital K-I-M. Lil Kim.
Ma'am, did you just say your name was Lil apostrophe Kim?
Yes, Your Honor.
And that's how you expect me to refer to you?
Or you could call me Mae West, Your Honor, or the Queen Bee, or the baddest bitch.
Miss Jones might be appropriate, Your Honor. Lil Kim is her stage name.
I see. Very well, Ms. Lil Kim. You're before me today for sentencing after trial, ma'am. Do the PD and DA agree that Ms. Kim was found guilty of perjury, felony of the 3rd degree?
Yes, Your Honor.
Now, do we also agree that this offense has an offense gravity score of 5, prior record score is 1 for prior lewdness, and indecent exposure?
Indecent exposure? I've never been locked up for indecent exposure. What?
Miss Jones, that was from when you went to the MTV Movie Awards half naked?
No, I had on pasties.
Pasties indeed. Your Honor, the prior record score is correct.
All right then, PD, I'll hear from you first with regard to what you think this court should do.
Well, Judge, as with any case that comes before this court, post-trial with no agreement for a recommended sentence, Your Honor has to look at the totality of the defendant's circumstances in light of the conviction. The defense will stress mitigation, Judge. Based on that mitigation and to some degree aggravation, Your Honor has to determine what will be a fitting sentence. In other words, how many mitts will it take till we get to a sentence that fits?
How many mitts will it take till we get to a sentence that fits? Or do you mean mitigation?
She's been a lot of places, seen a lot of faces, yet and still she hasn't had a lot of cases. She comes before this court with a minimal score. She's never even had probation before. When you think of criminals and you think of her crimes, you've got to ask, what's the commensurate time? The bottom of the guidelines is the place to start. Society's protection is just one of the parts. If you check her history, you'll see that she's had it pretty bad. Grew up poor without her mom or her dad. She had it rough coming up in the streets in the hood. But up until recently, she's been doing pretty good. So how many mitts will it take till we get to a sentence that fits? How many mitts will it take till we get to a sentence that fits?
Wow. Okay. DA?
Judge, I got nothing.
Well, despite that inspiring argument from counsel, I still find the need to address the pre-sentence investigation. PD, what do you have to say about the fact that Ms. Kim still hasn't accepted responsibility for this crime? According to the subject's version of events, she denies perjuring herself.
Your Honor, snitches get stitches, Judge.
Indeed. And PD, I have to say that I find Ms. Kim's choice of leisure activities somewhat troubling. The subject stated that she enjoys sipping Cristal with them real ones, whatever that means. Do we need a drug and alcohol evaluation here?
Judge, I don't think that would be necessary. She's been convicted of perjury.
Although this isn't a VUFA case, I would note she claims that she stashes 380s in Mercedes while someone named Puffy holds her down baby.
Judge, I have argument as to that.
I bet you do.
Your Honor, what you said.
Come again?
That's my argument. I mean, Your Honor, given that the defendant has yet to accept responsibility for this crime, and given that her act of perjury was an attempt to cover up a violent street crime, I would be asking for a guideline sentence in the aggravated range. She tried to cover for her friend who shot someone.
Well, Miss Kim, I've heard enough. I think I have enough information to make a decision. I know I've heard you on the radio.
True.
I know I've seen you on the video.
True.
But these things don't mitigate your sentence. You're in need of some serious attention. You're a risk I've got to get off the streets. I'd be more comfortable if you were in immediately. And please know I'm not trying to unduly punish you. But I have to let you know that we'll be putting these cuffs on you. Sheriff!
You're not gonna do something? Come on, come on. Say goodbye.
Your Honor, you didn't even
Come on.
sentence her.
6 to 12.
Locked up, they won't let me out. They won't let me out. Locked up, they won't let me out. No, they won't let me out.
So Byron, what do you think?
Well, the judge wasn't clear. She didn't say 6 to 12 what, but let's just say it's 6 to 12 years. How about triple RI, Sarah?
Well, normally you would think that somebody with just a perjury conviction would get that, but you've got an open lewdness conviction.
And that
With-
knocks you
with
out of
that-
triple RI?
According to our handy-dandy triple RI cheat sheet that's available to everyone. Open lewdness excludes you from triple RI.
Wow. Well, how about if the public defender had said to the DA, how about letting little Kim be triple RI eligible? Would that have worked?
That's something that they could have asked for. Definitely, the public defender could have asked to have the triple RI waived, and there's a whole procedure for that.
And if the DA agreed, then the judge could have ordered triple RI. Is that correct?
There's certain requirements of notice to a crime victim, but since you're talking about perjury, they wouldn't apply here.
So that was a mistake on the public defender's spot.
That's your comment.
So remember, everyone in the audience, always try to ask for triple RI. If it doesn't fit under the cheat sheet, ask the DA to waive the requirements. You can do that. If the DA agrees, then the judge can order triple RI.
You might want to explain what triple RI is.
Why don't you do that, Sarah?
Well, triple RI, it's a program, it's required, if someone is eligible, it's required to be imposed at the time of sentencing, and it allows for a reduction, it basically creates an alternative minimum sentence and makes the defendant earlier eligible for parole at an earlier point.
So on a 6 to 12 year sentence, what would be the triple RI minimum?
I'm afraid you were going to ask me that. That would knock it down to 50 months. The defendant would be eligible for parole at 50 months rather than, nope. My
60.
math is wrong. 6 years would be 72 months, that would knock it down to 60 months. So it would make them eligible, it would make Lil Kim eligible for parole a year earlier.
A year earlier. So the
Oh.
defense attorney should always ask that the client be triple RI eligible. Oh, by the way, Sarah, do you know that 6 to 12 years on a felony F3 is an illegal sentence?
Apparently so.
And the maximum on an F3 is 3.5 to 7 years.
That's correct.
So maybe the judge meant 6 to 12 months.
That's correct.
Little Kim, maybe you caught a break.
But you guys can't define me, define my work as a father. I'm many things, you know. I'm many things. Yeah, I'm a convicted rapist. I'm a hell raiser. I'm a father, a loving father. I'm a semi-good husband. You know what I mean?
Did we leave the music on?
Hey! Shh! Don't make any sudden movements. Who the hell are you? Oh, who the hell are you? Quiet, quiet. Mike Tyson? Shh! This is my favorite part coming up right now. I can feel it coming in the air tonight. Hey, close, my guy. Oh, Lord. But I've been waiting for this moment for all my life. One more time, guys. Oh, Lord. Oh, jeez.
Next on your honors list is Mike Tyson, or should I say Mike Tyson in this corner.
Hands up. Down. Sit straight. Hands up.
Your Honor, this will be an open guilty plea.
To simple assault?
Yes, Your Honor, as an M2.
Put your hands up.
Commonwealth?
Yes, Your Honor. Tyson. On February 11th at approximately 8:30 a.m., the complainant, Jose Schmoe, was in the area of 13th and Filbert Streets, located in the city and county of Philadelphia, when a pigeon flew directly into his face and began pecking his eyes out. Mr. Schmoe defended himself from harm using control holds to take the pigeon to the ground. The pigeon was unfortunately decapitated in the process due to the fact that it wouldn't stop resisting. Pigeons don't resist. After Mr. Schmoe had taken the pigeon to the ground, the defendant immediately and without provocation from Mr. Schmoe punched the complainant in the face using a closed right fist, and the complainant was rendered unconscious. Thank you, Your Honor.
I find the defendant guilty of simple assault as a misdemeanor of the 2nd degree.
Your Honor, can I say something?
Not only may you say something, Mr. Tyson, but you have an inviolable right to do so. It's called a right to allocution. Go right ahead, though I'd recommend that you run whatever it is you want to say past your lawyer first.
I don't got no lawyer. I'm broke. I couldn't afford a real lawyer. All I got is one of them paralegals from the public pretender's office. Man, I probably know more about the law than she does. Your Honorable, majestic judge, I pray for the leniency, compassion, and conciliation of this great court. I'm a changed man. I can control myself now, Your Honor. I know I can. You see, Your Honor, when I was a kid, one morning I woke up and found my favorite pigeon, Julius, had died. I was devastated, and I wanted to use his crate as my stickball bat to honor him. I left the crate on my stoop, and when I went in to get something, the sanitation man put the crate into the crusher. And I rushed him and caught him flush on the temple with a titanic right hand. He was out cold, convulsing on the floor like an infantile retard. Man, Your Honor, when Mr. Schmoe ripped my pet pigeon's head off that day, I wanted to rip out his heart and feed it to him. I wanted to rip out his stomach and eat his children. But I didn't, Your Honor. I think that Zoloft they put me on for keep me from killing y'all, it's working. It's making a difference. Because instead of doing what I wanted to do to that pigeon-killing motherfucker, I only punched him in the head instead.
Thank you. Looking at your criminal record, I can see that you really should know about your right to allocution by now. 38 arrests by the time you were 13, a rape conviction in 1992, conviction for assaulting a motorist in 1999, and to top it off, a conviction for DUI, possession of a controlled substance, in 2007. PD, you're up.
Your Honor, my client hasn't had it easy. He's a product of his circumstances, and because of this, I'm asking for no further penalty. Your Honor, my client has a nationally televised television show. He's surrounded by cameras every day, recording his every move, and that footage is broadcast to the entire nation. Not even the officers of Philadelphia's probation department can subject people to that kind of scrutiny.
Nice try, counsel. I'm sentencing him to 11.5 to 23. 10 days to reconsider, 30 days to appeal.
You stay.
Locked up, they won't let me out. They won't let me out. Locked up, they won't let me out. No, they won't let me out.
So, Byron, what did you think?
Well, I thought Mike did a wonderful job, and the public defender, although I believe she is really a lawyer, isn't she, Sarah?
Yes, they are.
I think the one thing the public defender could have done is ask that Mike be reentry eligible after the judge sentenced Mike to 11.5 to 23, or also ask for work release.
Why would that make a difference, do you think?
Well, if
Explain.
reentry eligible, then the public defender could ask at some point down the line, before the 11.5 is up, to parole Mike early. And we all believe that Mike should be out of jail on the street because he's taken his Zoloft now.
Well, I don't know, I agree with you there, Byron, but it is clear that he can't be paroled prior to his minimum date of 11.5 months unless the judge has made him re-entry eligible at the time of sentencing. That's based on the new law that passed in 2008.
And also, the public defender stated 10 days to reconsider, 30 days to appeal. She should have stated 10 days to reconsider, and that must be filed in writing, and the 30 days to appeal to the Superior Court must also be filed in writing. And if Mike can't afford a lawyer, as he said, then the court will appoint one free of charge. She should have given those rights.
Thank you, Byron.
Thank you very much.
Let's talk about something exciting. Me winning. I'm an F-18, bro. Winning.
I love being under house arrest. What do I get for good behavior?
Charlie Sheen and his attorney are talking. Time is 1 year prior to present day. They're discussing case strategy for Charlie's open domestic violence and DUI cases.
Look, man, I'm not getting up there and pleading guilty. Those cops put a suitcase of cocaine in my car.
Charlie, we've been over this. The state is charging you with driving drunk and with blacking out that porn star's eyes, nose, and big toe. No one even knows what suitcase you're talking about.
Oh, I remember both those nights. A rarity for me. I'm going to lie, but yeah, I'm not going to lie, but yeah, I totally did those things.
You mentioned Charlie. To me and anyone else in the courtroom at your 404 listening that would listen, that's why we asked the court to put your cases together for this consolidation. This way you can dispose of them all at once. The district attorney has offered to let you plead guilty to the lead charge on each case in exchange for you doing 30 days on state road with a bit of probation after.
Oh man, what a deal! But wait, what about my driver's license? One of those jailhouse lawyers at the Roundhouse told me DUI convictions come with a license suspension. Now I got a movie shooting at the Greyhound terminal in Harrisburg starting in June. And there's no way I'm doing anything but driving back and forth from Harrisburg to Philadelphia each day for filming. You know, the quality of call girls in Harrisburg is unacceptable for a big movie star like myself. And whatever they use to cut their heroin out there gives me a nasty case of the runs. Oh!
I didn't hear that, Charlie, but you have nothing to worry about. The drunk driving statute in Pennsylvania does not mandate a driver's license suspension in first offense general impairment cases like yours.
Great. So wait, that means 3 meals a day, free jammies, and a bed of my own? This is going to be the best 30 days ever. I can't remember the last time I spent that many days in a row sober.
All right, Charlie, so you're going to plead guilty to the 2 cases today?
Totally winning.
Next on Your Honor's post-trial list is Charlie Sheen, here for a violation of Your Honor's probation.
Where's the probation officer?
He called the courtroom this morning, Your Honor, said he couldn't make it and offered to send an intern. He said he filed a motion because Charlie Sheen landed his butt in trouble again. Something about the defendant getting locked up for driving without a license.
You want him, Judge?
Yeah, bring him out.
Rhymes with winning. Charlie Norlington.
Okay, sit. Sit. Put your hands on the table. Up, sit up straight. Stand up, in fact.
Your Honor, my PO is lying on me here. These cops too. No one here's on Team Charlie. I mean, but Charlie, you see, Your Honor, my license wasn't suspended. My lawyer said because I wasn't drunk when I got locked up, There wouldn't be no suspension, Your Honor.
Mr. Sheen, that's not true. A jail sentence of any length in connection with a DUI conviction automatically triggers a driver's license suspension. Didn't you get a letter from PennDOT asking you to turn your license in?
Well, yeah, but I thought they were just trying to get my stuff to sell on eBay. You know how popular star I am.
You were already convicted in traffic court for driving with a suspended license.
Judge, I was going to court on that day. I really was. But then I just got high.
Welcome to the world of conviction and absentia, Mr. Sheen. Now, you've already served 2/3 of the mandatory jail sentence for driving with a license suspended in connection with a DUI conviction, while on my probation, no less. And now you're telling me that A, everyone has collaborated against you, and B, that you thought the whole post-sentencing ordeal was some sort of nefarious plot on the part of PennDOT to make money on eBay? You know what, Mr. Sheen? I'm going to do you the kindness of pretending that instead of feeding me that ridiculous story, you stop talking after, well, yeah. At this point, I'm going to revoke your probation and sentence you to a new term of 6 months probation on your DUI to run consecutive to the 2 years probation you already owe me on your domestic case.
What can I say, Your Honor? I like my violence like I like my beer. Domestic.
Your Honor, Mr. Sheen has filed appeals in common pleas court on both his driving with a suspended license charge and the suspension of the license itself. Finding him in violation at this point is premature.
Counselor, you can file all the appeals in the world. Suspension of a driver's license follows a jail term stemming from a DUI conviction. And driving with a license suspended for that reason automatically triggers a mandatory 60-day jail term. There simply are no two ways about it. But, procedurally, you're correct. Detainers to remain. These matters are continued until further notice.
Come on, Mr. Sheen, let's go, let's go. You're done. This way.
Locked up, they won't let me out. They won't let me out. Locked up, they won't let me out. No, they won't let me out.
Guess who we have as an expert today? Tom Ivory. Now, did you see any problems with the script?
Well, some interesting issues about driver licensing and DUI issues came up, all right.
Can you enlighten us?
Well, sure. One of the things that the lawyer told his client, Charlie, was that he had nothing to worry about. The drunk driving statute doesn't maintain a license suspension in first offense general impairment cases like yours. Well, that's true unless the person gets a prison sentence. And a lot of lawyers are letting the DUI get a prison sentence when it doesn't need to, especially in 701 cases. That carries a suspension.
Can I ask you a question? Would a time in to 12 months be considered a prison sentence and a DUI suspension?
Yes.
Yes, I see a lot of lawyers make that mistake.
Yes. So even a first DUI with general impairment carries a 12-month suspension if there's a jail sentence. Another thing was the judge asked Charlie, didn't he get a letter from PennDOT? And that letter tells the person that they have to turn in their license or their acknowledgement of suspension form. Otherwise, they don't start getting credit on their suspension. A lot of the time, people go to get their driver's license after a year has passed, and lo and behold, they haven't even begun their credit.
Because they didn't send back the letter?
Or their license. They have to send back one or the other. Another thing is, Charlie's lawyer talks about 2 appeals. When a person gets a traffic court conviction for driving while suspended for a DUI, they can appeal the suspension and they can appeal the conviction that led to the suspension. When they appeal the suspension, that stays the suspension pending the outcome of the appeal of the conviction. So when you have a client like in that situation, you have to file 2 appeals, one in civil court and one in criminal court. The other thing that I noticed was the judge said something wrong.
The judge said something wrong?
Yeah, can you believe it?
That's incredible.
The judge said that driving while suspended automatically carries a 60-day prison sentence. Thank goodness it's not automatic. There's due process even for DUI clients. And you get a traffic court trial, and if you're convicted at the traffic court trial, you get to appeal for a de novo trial in the Court of Common Pleas. There's 2 trial steps that the Commonwealth has to go through before you do that 60-day prison sentence.
Well, wasn't that very informative, Sarah?
Yes, it was. Just to mention, Byron, we have for the folks here, we have a DUI sheet with all of the various mandatories available for everybody after this is done.
Simplest, blunt question. You're clean and sober?
Yes, I'm good, and I'm clean and sober.
Yeah. How long has that been?
It's been a while. It's been a long time.
Defendant is ordered to spend 30 days in jail on the reckless driving case, 30 days in jail on the first DUI case consecutive, and 30 days in jail on the second DUI case consecutive. That's 90 days in jail. The court is also going to order Dr. Sharma, or appoint Dr. Sharma and Malinak, Kajal Sharma and Hyde Malinak, to interview the defendant because within 2 days of her release from jail, she's ordered to report to probation and she's ordered to do a 90-day inpatient substance abuse program. And I want Dr. Sharma and Malinak to indicate to the court and write a report to the program, as to probation, as to the type of program that would best benefit her.
Next on Your Honor's post-trial list is Lindsay Lowen, here for VOP.
Your Honor, Lindsay is here before you today with technical violations. This is her 8th VOP hearing since Your Honor convicted her on the retail theft for stealing a cheesy necklace.
It wasn't cheesy. It was way cute.
Your Honor, sentenced Lindsay to 6 to 12 months of house arrest with a year probation tail.
All right, here we go.
Well, Your Honor, to start, Ms. Lohan violated her house arrest by leaving her home without authorization.
I just went out on my front step just to do a quick run.
And when I arrived yesterday for an unscheduled home visit, I saw that there had to be 5 pounds of loose marijuana on her coffee table. Possessing 5 pounds of marijuana obviously brings yet another violation, Your Honor.
But Your Honor, I had someone bring it to me. I didn't have to leave the house to get it.
Unsurprisingly, Lindsay's last 16 drug screens have been positive for marijuana, benzos, opiates, and an unidentified substance that Ms. Lohan has identified as Wolverine tranquilizer.
You just don't understand how hard it is to be beautiful and famous. I need that tranquilizer. I paid that vet good money to write me that prescription.
Last but not least, Your Honor, Ms. Lohan is also facing animal cruelty charges for savagely attacking a paparazzo's chihuahua with her iPhone.
Lindsay, I have had it up to here with you. It's like you think the law doesn't even apply to you. Counsel, can I revoke her probation even though it hasn't started yet?
Oh, Your Honor, you can sentence her to her back time. You can revoke. The world is your oyster. I mean, really, why not do both? Do both.
Your Honor, I ask to pause for one moment. Think about what my client has been through. Growing up in the spotlight can't be easy. And my client's estranged father has been in and out of jail for the last several years. I think a downward departure from the guidelines is clearly warranted.
As I'm sure you're aware, PD, the sentencing guidelines don't actually apply to BOPs. All right, I think I've heard enough. Stand up, Ms. Lohan. I'm revoking your probation, which you have impressively managed to violate without getting to the probation part. And I'm going to sentence you to 11 and a half to 23 months incarceration. And that's consecutive, Lindsay. So the mandatory sentence you're going to be looking at for those 5 pounds of marijuana you didn't leave your house to get. Enjoy your stay upstate.
But wait, I thought if I got less than 2 years, I could serve it in the county.
Come on, ma'am. Let's go. Let's go. Let's go.
Sorry, Lindsay. Back
Let's
time
go.
gets served
Let's go.
consecutively. I'll write to you at Muncie.
It's just
Wait,
because
come on.
it's just because I'm so beautiful. You're all jealous of me.
Yes.
Locked up, they won't let me out. They won't let me out. Locked up, they won't let me out. No, they won't let me out.
Sarah, you know, these commentaries are sort of going down the toilet, don't you think?
Absolutely.
Well, Sarah, now you know how it feels.
Well, all I know is I think they've cut our budget. Not much for a studio here, is there, Byron?
No, we're going downhill fast. But there's a lot to talk about in this one. Sarah, let me ask you a question. Can the judge revoke the parole and also revoke the consecutive probation?
Yes, that's right. She could have revoked the parole and revoked the probation that hadn't started yet. It's an anticipatory revocation of probation.
Unfortunately, you're right, Sarah.
Well, what do you think about the original sentence, Byron? The original sentence was to house arrest for a period of time.
Well, that's an illegal sentence. It has to be 6 to 12 months immediate parole to house arrest, or the prison will not let Lindsay out. There's another question, whether the judge can sentence consecutive to a sentence which has not been given. The judge at the end said she was sentencing Lindsay to 11 and a half to 23 months, consecutive to the mandatory sentence she was going to receive in the future for the 5 pounds of marijuana. Can the judge do that?
Absolutely not.
Right. So, in fact, Lindsay's sentence is 11 and a half to 23 months, and she will be staying in the county prison. Isn't that a great, happy moment in our lives?
Well, as you know, certainly the places of confinement rules have changed, and so now any aggregated sentence of 2 or more years will automatically send you to state custody, regardless of what the individual sentence is or what the judge says. But in this particular case, because the only thing that happened was the probation was revoked and a new sentence was imposed, and it wasn't made consecutive to anything else, this could be a county sentence. But the judge could have easily made it a state sentence just by making it, revoking the back time and making the new time on the probation revocation consecutive to it.
That's true. But for now, Lindsay will stay in the county.
My favorite word is huge. Huge is the new that's hot.
Give it a date, Your Honor. Give it a date. Judge, we're going to stand as the post-trials now. Number 44, Judge Hilton. That's a VOP. It's got open bills, Judge. CFN. Give it a date. We already gave it a date. Give it a date.
Which case?
It's got open bills, Judge. CFN. Give it a date.
Yes, but what case?
Paris Hilton, Judge.
Is the PO still here?
Yeah, Judge, but she's got open bills. CFN, Judge. Give it a date.
If this is the Paris Hilton case, I want her brought up.
Put your bag down. Give it to counsel. Put your hands on the table. Wait till I move the chair in. Stand up again. Go ahead, sit.
Next case on the list, Judge, is 44, Hilton. Open bills, Your Honor. Open bills. See if I...
Thank you, Crier. All right, swear the witnesses in.
Do you swear? Oh. 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 No. You swear to tell the truth, the whole truth. None but the truth, so help you God.
I do.
This is boring.
P.O., I'll hear from you first.
Yeah, Judge, basically Ms. Hilton has open bills.
Open bills, Your Honor. See if I...
Right, that has been made abundantly clear to me. What's the nature of the open bill?
It's a DUI and a possession, Judge. Possession of cocaine. Ms. Hilton was first sentenced by Your Honor in December of last year. She was convicted of DUI, general impairment, and received a sentence of 10 days in jail and 2 years probation. That was her 4th DUI. Her open case, if she were convicted, would make it a 5th DUI. The open case alleges the presence of drugs in the blood, Your Honor.
Does she have bail on the new case?
Yes, Judge, $100,000.
Oh, there goes my lunch money.
Really, Miss Hilton? You're really coming back in front of me with this kind of case? Do you remember what I told you last time I saw you? Say you're sorry.
You're sorry, Judge.
Say I'm sorry.
This lawyer is sorry, Judge. Anyway, I think I remember that you said I would go to jail and stuff.
And yet, here we are again. You have a serious problem, Miss Hilton.
It's nice to see you too, Judge. That robe is hot.
Wow. Well, one thing's for certain. This detainer, not getting lifted. Miss Hilton, I intend to CFN this matter.
That's what we should have done in the first place. Give it a date.
I'm going to CFN this for a year. That way you'll at least be at your minimum date for this new DUI.
That sounds reasonable.
That's not hot.
Actually, Your Honor, I think if you're trying to cut Ms. Hilton a break, and I'm not saying that you are, if you do, and there's a chance at all of Ms. Hilton's pretrial credit will go to the other case.
At the end of the day, and I'm looking at you when I say this, Ms. Hilton, you really might want to think that a second one.
Judge Means is really tough.
Time credit, Sarah.
You've always wanted to do that, haven't you?
I have, man. It's been a long time. Finally, I've done it. Time credit.
So what do you think about Paris Hilton in this case?
Well, she's hot. But if we want to talk about time credit, where the judge continued it for 1 year, that's not a good idea.
Why?
Because she's losing all that time credit. When a person's sentenced when there's 2 open matters, the first one takes all the time credit. So if she waits 1 year and then she's sentenced on the first case, she'd have all that to the first sentence. However, she have no time credit on the second one, because the second case, the sentencing would start on date of imposition.
So,
And that's a fact.
So in other words, by having a CFN, she's probably going to do more time, substantially more time.
Absolutely.
So she won't be on the road as a drunk driver during all that time.
Well, that would be your argument. But because Paris is so hot, I think we would like to get her out as fast as possible. Wouldn't you, Sarah?
No, CFN is sounding mighty good to me.
Well, as the defense counsel, I would say she should handle the cases as fast as possible so that she can get the time credit as quickly as possible. Wait, Sheriff, before you close that down, would you please bring Little Kim and Lindsay Lohan in to join us?
I am so out of here.
Out in Queens, push the red ball back. She's pumping weight in and out of state, lights and plate. See your lifestyle is straight weight. She's into licking shots, sticking blocks. Got a shorty on the team. The shorty's into picking locks. and the crew stay right, getting high too. Lex scoops and jeeps got people